Hi guys, I hope you all are doing well. This is Harshpreet Kaur and you're watching Legal Bites. In today's video, we will be looking at the legal maxim actionable per se. In this video, I'll be looking at the meaning and origin, the application of the maxim, a few illustrations, and last but not the least, some important case laws to understand the maxim better. So let's get right into the video. Let's take a look at the meaning and origin of the maxim actionable per se. So actionable per se is a legal maxim which finds its roots in the Australian law. In order to understand the meaning, we'll break down the maxim into two terms. One is actionable and second is per se. तो actionable तो word से ही समझ आ रहा है. क्या meaning होगा इसका? Act या फिर action. And per se in Latin means by itself. And hence the term actionable per se literally means that the act or action is punishable by itself and no proof of damage is required. So now that we know the literal meaning of the maxim actionable per se, let's understand it from a legal perspective. So the maxim is generally applicable in torts, and in torts, a proof of damage or evidentiary value is required. But there are certain exceptions to this same, and there exist torts which are actionable per se and no proof of damage is required. Such torts are actionable only because of their happening. Next is the application of the maxim. So the maxim is generally applicable in cases such as that of assault, battery, false imprisonment, libel, which is written defamation, trespass, etc. In such cases, the act itself is the proof and no additional proof of damage is required. Additionally, it is insignificant in such cases if the plaintiff has suffered any damage as the result of the act, and the act itself can be made punishable. So now let's take a look at this illustration. So there's A and there's B. Right when A was going to sit on the chair, B pulls the chair and A falls down. Irrespective of whether A got any hurt or not, B will be liable for assault under the Indian Penal Code because the act is actionable per se and no proof of damage is required. Now let's take a look at these case laws. The first case is that of Ashby versus White. It is a very famous case. So in this case, the defending officer prevented the plaintiff from registering his vote, while the plaintiff was completely eligible to register his vote. Despite of all of this, the person for whom the plaintiff was going to vote won the elections. The court in this case held that the act of the defending officer was punishable and actionable per se and no proof of damage is required. इस बात से फर्क नहीं पड़ता है कि प्लेंटिफ जिसके लिए वोट करने जा रहा था वो जीता या हारा. Plaintiff was being deprived of his right to vote and hence the defending officer was held liable in this case. The next case is that of Shrikant Roy versus Satkori Shah. So in this case, the plaintiff gave false evidence in the court of law and वो पकड़ा गया. तो अब इस बात से फ़र्क नहीं पड़ता कि उसके false evidence देने से decision गलत हुआ या decision ठीक निकला. इस बात से फ़र्क ही नहीं पड़ता because the act is actionable per se and no proof of damage is required, and so in this case the plaintiff was held liable for giving false evidence in the court of law. So this is it for today's video. Thank you so much for watching our video. Please do not forget to like, share and subscribe to our YouTube channel. Additionally, there's an article on the same maxim, the link to which can be found in the description box below. Thank you.